Hello everyone, hope you have an amazing day and welcome to my new blog. Today our topic is the Industrial Disputes Act 1947, Act number 14 of 1947, an act to make provision for the investigation and settlement of industrial disputes and for certain other purposes also. Whereas it is expedient to make provision for the investigation and settlement of industrial disputes and for certain other purposes hereinafter appearing. It is hereby enacted as follows. Now I discuss about details. Statement of objectives and reasons. Experience of the working of the Trade Disputes Act 1929 has revealed that its main defect is that while reactant have been imposed on the rights of strike and lockout in public utility services on provision has been made to render the proceeding institutionally under the act of the settlement of an industrial dispute, either by reference to a board of conciliations or to a court of inquiry, so conclusive and binding of the parties to the disputes, and that this defect was overcome during the wear of empowering under rules 81A of the Defense of India rules the central government to refer industrial disputes to adjudicators and to enforce their awards also. So rules 81A, which was to lapse on the 1st October 1946, is being kept in force by the emergency powers, Constituance, Ordinance and 1946 for a further period of 6 months. And as industrial unrest in checking which this rule has proved useful is gaining momentum due to the stress of post-war industrial readjustment, the need of permanent legislations in replacement of these rules is self-evident. So this bill embodies the essential principles of or R81A, which have proved generally acceptable to both employers and workmen, retaining intact for the most part the provisions of the Trade Disputes Act 1929. The two institutions for the prevention and settlement of industrial disputes provided for in the bill are the Works Committee, consisting of representatives of employers and workmen, and industrial tribunals consisting of one or more members. So, possessing qualifications ordinarily required of appointment as judges of High Court power has been given to appropriate government to require Works Committee to be constituted in every industrial establishment employing 100 workmen or more, or their duties will be to remove cases of friction between the employer and the employees or workmen in the day-to-day working of the establishment, and to promote measures for securing amity and goods relation between them. Industrial peace will be most enduring where it is founded on voluntary settlement, and it is hoped that the Works Committee will render recourse to the remaining machinery provided for in the bill of the settlement of disputes and infrequent. A reference to an industrial tribunal will lie where both parties to any industry disputes apply for such reference, and also where the appropriate government considers to uh, disputant so to do. An award of a tribunal may be enforced either wholly or in part by the appropriate government for a period of one existing 1 year. The power to refer disputes to industrial tribunal and enforce their awards is an essential corollary to the obligations that lies on the government to secure conclusive determination of the disputes with a view to redressing the legitimate grievance of the uh, parties thereto. Such obligations arising from the impositions of restraints of the right of strike and lockout, which most remain inviolate, expect or except where considerations of public interest override such rights. The bill also seeks to reorient the administrations of the conciliations machinery provided in the Trade Disputes Act. So, conciliations will be compulsory in all disputes in public utility services and optional in the case of other industrial establishment, where a view to expedite conciliations proceedings time limits have been prescribed for conclusions thereof 14 days in the case of conciliations officer and 2 months in the case of conciliations proceedings will be binding for such a strike. A settlement arrived at in the course of conciliations proceedings will be binding for such period as may be agreed upon by the parties and where on period has been agreed upon for a period of 1 year and will continue to be binding until revoked by a 3 months notice by either party to the disputes. So another important new feature of the bill relates to the prohibitions of strike and lockouts during the tendency of conciliations and uh, adjudications or proceedings for settlements reached in the course of conciliations proceeding and of awards of industrial tribunal declared binding by the appropriate government also. The underlying argument is that where a dispute has been referred to conciliations for adjudications, a strike or lockouting furtherance thereof is both unnecessary and inexpedient where on the date of reference of conciliations. So or adjudications also. A strike or lockout is already in existence. Power is given to the appropriate government to prohibit its continuance, lest the chances of settlement of speedy terminations of the dispute should be jeopardized. So the bill also empowers the appropriate government to declare, and in public interest or emergency so requires by notifications in the official gazette, any industry to be a public utility services for such period, if any, as may be specified in the notification, Published Gazette of India at 1946, PTVP 348. Now, number 2, Amending Act number 41 of 1956. Doubt has been raised whereas retrenchment compensations under the Industrial Disputes Act 1947 becomes payable by reasons merely of the fact that their has been a chance of employers, even if the service of the workman is continued without interruptions and the terms of conditions of the services remain unaltered. This has created difficulty in the transfer, reconstitutions and the amalgamations of companies, and it is proposed to make the intention clear by amending section 25F of the Act. Now, the question have also been raised, whereas a workman who is laid off for more than 45 days continuously is entitled of to layoff compensation for any period beyond the first 45 days. The opportunity has been taken to remove the ambiguity to specifying the circumstances under which such compensations beyond the first 45 days would be admissible to a workman. Published in Gazette of India 23/4/1956, PT 2 S2. So, Amending Act 36 of 1964. The bill seeks to make change in the Industrial Disputes Act 1947. The important charges in the Act were discussed at various tripartite meeting like the Indian Labour Conference and the Standing Labour Committee, and have their approval. Section 7A of the Act lays down the qualification of appointment as the presiding officer of the tribunal. The state government have been experiencing difficulty in getting suitable person for appointment as presiding officers of tribunals. Many of the state governments have accordingly amended this section in its applications to their states, enabling district and sessions judges to be appointed to this post. It is now proposed to provide for the appointment for a serving or a retired district judge or additional district judge or not less than 3 years standing as a presiding officer of the tribunal. In order to encourage arbitrations, it is proposed to provide one for the appointment of umpires of case of the difference of opinion between an ever number of arbitrators. 2. For provisions of strikes and lockouts during arbitrations proceeding, and 3. For application of section number 33 during the tendency of any arbitrations proceedings further, and arbitrations award is binding at present only on the parties to the arbitrations. These positions is discouraging employees for agreeing readily to voluntary arbitrations as they cannot enforce it on the workers who are not a party to the agreement. It is now being provided in the bill that is arbitrations award shall have the same binding force as an award of a tribunal, provided that the appropriate government is satisfied that the parties to the agreement represents the majority of each party. That's for the video, my friends. My humble request is, if you like my video, please subscribe my channel. Thanks for watching my videos.